In the context of state and government's liability in tort, we will discuss a French model, and that is known as fault theory. So, under the very fault theory, the first principle is that personal fault, and that personal fault is in French it is called faute personally. So, in Brown and Garner, in French administrative law, so they explain use of government vehicle for private purpose may be sued personally in ordinary courts as its importance in keeping the administration on tap, and the second principle, that is service fault or fault.ii.service, as in regarding this principle in exercise of public function for service, the injured party must sue the administration before the administrative courts. And as regarding the third one, the third principle, that is service connected fault with the development of the concept of welfare and service state, the concept of faults connected with the service is expanding tremendously, and courts are recognizing combination of faults, and the state could be held liable for the whole damages claimed. So also it was held in the Council d'Etat in 1911, and in case of Mumer, Defox and Bestlemer in 1949, the very complaint suffered injuries by negligent driving of the governmental officials. So the government vehicles used on private and unauthorized trips by officials. So also another principle that is falling under fault theory, that is the fourth one, and it is contribution. So the council that developed the concept of contribution in cases where the officer is on a frolic of his own means, the irresponsible and reckless behavior of the officer dealings with public. So also in the Delville case in 1951, a government vehicle involved in an accident as the driver was drunk, and partly because of the defective brake, so 50% contribution by the administration and the driver each was held by the council d'etat. And the fifth principle and theory is the risk theory, and the jurisprudential basis for liability without fault is that of the risk theory. The moving spirit behind this no fault liability is perhaps the fundamental principles of equality of all citizens in bearing public burdens. So, state responsibility on the ground of no fault theory has been identified in various typical spheres of government activities, such as the responsibility for damages arising from dangerous operations. So during First World War, certain grenade dump in a residential neighborhood exploded, causing extensive damage to the person and property. So, in Renault and Dijon's case, in Council d'Etat in 1919, the risks show the victims need not to establish the very negligence or fault of the state. So also in Locomet and Daramy, the council died in 1949 held bystander injured as the police used firearms while pursuing an assailant, so the state was held liable. So also, workmen compensation principle in public law of tort, where in Kemp's case in 1895, the council did held employee working in state arsenal injured himself. So also in Saint Law Plan in 1946, the council did held person injured to set a fire in village carnival. So also in Pingwet versus 1953, the council that held person injured while apprehending a thief. So also in Gillard's case in 1970, person injured himself while rescuing an old woman out of a ditch. She had fallen accidentally. So these are the leading cases relating to the risk theory, where in some cases the state or the administration was held liable, and in certain cases also the very individual and who was a defendant, a plaintiff, also held liable. So, in regarding the sixth theory, that is compensation for governmental refusal to protect the legal interest and rights of the people, and in that, in county case in 1923, council did that held government's inability to get the land of the plaintiff vacated by the nomadic tribes because of the fear of civil war, where the administration was held liable. So also the very seventh principle governing the fault theory, compensation for governmental action imposing statutory unequal sacrifice, and in that case in Mirugi in 1971, council did that held that statute is silent. Equality in bearing public burdens falls on both the administration and the plaintiff. So also in Indian context, now we'll discuss the very concept of sovereign immunity, and that is the very role and function of a government in a welfare democratic society. So also equality between the governors and the governed, and socialization of compensation versus immunity granted to the state. So also the very concept of sovereign and non-sovereign functions, where there is logical fallacy and practical absurdity. So liability should be through budgetary reorganization and not shifting the burden to the helpless victim, and it also developed a public law of tort for which the blueprints have been provided by the French jurisprudence. So also the governmental liability in a welfare democratic society. Damage to any private citizen arises often from actions taken in public interest. The socialization of compensation must be the foundation on which the infrastructure of the law relating to governmental liability in tort must be built, whether the government can also recover damages from any private individual for the tort committed against its servants. So, in relation to that, a leading case in Inland Revenue Commissioner versus Hamburg in 1956, Lord Justice Denning expressed that government, corporations, and other employers are not having household. So there is no question of tort. So also in the Commissioner for Railways versus Scott in 1959 by the Australian High Court held that government can recover damages from private individual for the tort committed. So to conclude, it is only hope that the Indian judiciary would register by developing the principle of public law of tort, satisfying the claims of socialization of compensation, the application of the action against private individual in tort in public law is still in its antenatal stage in India and deserves serious consideration bridge from the bench and the bar. So exactly as regarding the state or government or administration's liability in tort as it was developed in French jurisprudence as under fault theory having seven certain developed principles. So those principles as applied in French jurisprudence to determine the liability of administration and as it is borrowed into Indian judiciary and that also regarding liability of state or government or administration in tort and as it came into a greater importance due to the very development of modern welfare state. So, for the very activities of administrators and the administration in the field of socialization and in social welfare state as it is increasing day by day, so how the state and the government and administration would be held liable, so also when there would be fault on the part of individuals, so also the individuals would be held liable and regarding that very concept of socialization of compensation as it was developed. So, the application of the action against private individual in tort in public law, even if it still in an antenatal stage in India, but it deserves serious consideration from both the bench and the bar, as the bench constitutes those learned judges, and as the bar also constitute the learned advocates, counsels, so due to their efforts, the very concept of socialization of compensation could be developed from its antenatal stage to a postnatal stage, which is the very requirement of the present Indian jurisprudence regarding to determine the liability of the state or the government or the administration in their action, as we are marching in a modern welfare state whose intention is socio-economic development, so both the administration and the private individuals would be equally liable in certain circumstances. So the very concept of socialization of compensation developed, and even if it is in antenatal stage, it must be developed with due contribution by both the members of bench and the bar to ensure its postnatal development in the very concept of state liability or governmental liability or the liability of the administration in tort